Good evening, ladies and gentlemen. We call to order the May 26, 2026 meeting of the Planning Commission for Dexter Township. I invite you to stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, and justice for all. Thank you, ladies and gentlemen. Secretary Meyer, would you please call the roll?
Commissioner Smith,
Present.
Commissioner Hurd,
Here.
Commissioner Straw,
Here.
Commissioner Barron.
Here.
I'm here, Commissioner Mayor and Chairman Birch.
Here.
Did Ms. Abbott contact you or?
Yes, Ms. Abbott contacted us approximately 6 weeks ago to inform us that she was not going to be available for the March meeting.
Oh, she had a graduation, that's right.
I don't know the reason. Thank you. Next item on our agenda is the approval of the agenda. Are there any additions, deletions, or changes we request to the agenda? Recording Secretary Miller.
You're finally going to resolve the minutes issue tonight. So on action item 8, B, the discussion and the decision regarding the direction of minutes, we're going to move that down to 10D. Because I want to go through all the different minutes with you so that you understand the process clearly and have all of your questions answered so that you can make that decision and the direction you want your minutes to go.
Thank you, Secretary Miller. Is there any discussion on the movement of item 8B to item 10D, I'm sorry. Hearing none, are there any other additions, deletions, or changes you would like to make to the agenda? Hearing none, the floor will entertain a proposal to adopt the agenda as amended.
So moved.
So moved by Commissioner Hurd,
I'll second there.
support by Secretary Meyer. Any further discussion? Hearing none, all in favor, say aye.
Aye.
Any opposed, nay? Motion carries. Our next item on the agenda is a conflict of interest if any commissioner has any conflict of interest with any item on the agenda, please raise that issue now. Hearing none, we will proceed with public comment for items that are not on the agenda. Any items that are on the agenda, we will incorporate public comment during the discussion of those items. Mr. Spiegel.
Joseph Spiegel, 7905 Tower Drive. I'm appearing as a citizen and not on any board. Am I on?
This is the light green.
Thank you. There's no purpose for an ordinance if you're not going to enforce it. You've been previously provided a cost estimate, a draft outline for a policy, practice, and procedure for enforcement. I understand Commissioner Abbott's thoughts on an anonymous tip line. We need an anonymous tip line because a plaintiff's name will not, or a complainant will not become public until there is some sort of filing or formal proceeding. It's not available under the Freedom of Information Act. It allows citizens on behalf of the township. It's called en parens patre. On behalf of the parent, on behalf of the township. That's a legal concept. It's pretty simple. It means that an individual can assert a claim on behalf of an entity, a governmental entity. Saves money. And no, we're not like Kentucky where you can hire your own prosecutor, because that comes from the Hatfields and the McCoys. It allows the enforcement of an ordinance, a statute. It helps keep the cost down. It's a small budget item. Any ordinance, law, statute must comply with due process. There's got to be notice and opportunity to be heard, and notice isn't going to be satisfied by publishing it in the Sun-Times in that area in the back of the paper. The question becomes on the fertilizer ordinance. Are you going to provide, I don't want an answer, notice of the ordinance to the providers? How do you get the providers? You can call Lara. You can look at the internet. You can ask artificial intelligence. Letters to providers that there's this ordinance, I think, is essential for its enforcement. I think you need to consult with new counsel. It shouldn't be costly. It could be a budget item. And you can ask your lawyer, can you make a demand on the providers of fertilizer for a list of their customers? They'll probably push back. Can Dexter Township issue a subpoena itself? How will you give notice of this fertilizer ordinance? So it would seem to me a letter to those persons living around the lakes, to any lake association, would be appropriate. It's a small budget item. It's a small task. This is not Cook County, Illinois. This isn't Wayne County. It's a small township. I did notice when the board asked for support for the 100 feet amount from the lake for fertilizer. No one provided science support. No one said you can go to Michigan State, you can go to the University of Michigan, you can go to Eagle. You can figure that out. So my concern as a citizen is there any legislative history which would support this ordinance? You may want to consider having someone do a little bit of research. Failure to engage in this inquiry may open up a lot of citizen objections. So what I'm suggesting is a deep dive into how you're going to enforce this ordinance. And this also applies to this upcoming controversy about data centers. The last verse.
There you go, sir.
I'm up my 3 minutes.
But
I reserve for my final.
thank you.
Thank you.
Any other members of the public care to address the planning commission? Hearing none, we shall proceed to the next item on the agenda, item 7A, public hearing to amend section 2.02 to modify the bed and breakfast definition and to add a short-term rental definition, to amend section 1704 K1, K3, K8, and add sections K11, K12, K13, to clarify and modernize bed and breakfast standards and to amend table 18.1 to modify bed and breakfast parking requirements. DPZ Ryer, would you please present this item to the commission?
Good evening, planning commissioners. Over the course of the past few months, we have been working on modernizing the existing bed and breakfast ordinance. With the help of Carlisle Wortman and staff, we have amended the B&B definition, added a short-term rental definition, fine-tuned the parking requirements, added building/residential code requirements to bed and breakfast, emphasized owner occupancy, and added some additional inspection/sanitary and sewer inspection requirements. From the last meeting, we did make a couple changes based on the Planning Commission's conversations. And one was replacing continuous with consecutive in section 2.02 and 17.04K9. And then changed building official to Chelsea Area Construction Agency in section 17.04K8. I'm going to pass the mic on to Brady. We do have a couple questions for you to consider before you head into conversation and deliberation about this topic.
Thank you, DPZ Ryer. Ready?
Good evening. So we had a couple of questions for section 17.04K12, which does require an inspection. However, we have a question for the Planning Commission. Should the inspection take place before the public hearing or before the Planning Commission makes a decision? And should there only be one inspection or should it occur annually?
Did you want us to address that issue now or as a part of the discussion for the entire amendment?
As a part of the amendment, whatever the outcome of these questions are, would be in the ordinance draft presented to the board. If you do end up recommending this ordinance.
Thank you, DPZ Ryer. Planning commissioners, anyone have any questions or comments regarding the proposal for defining and the ordinance for use ordinance for short-term bed and breakfast and short-term rentals? DPZ Ryer, I do have one starting out bed and breakfast. The definition, a single-family residential facility with a rental period of less than 30 consecutive days. I am not comfortable with the wording on that because are the customers limited to 30 consecutive days, or are the owners that are renting the property limited to 30 consecutive days? I think it could be worded more concisely and in a manner that we can let the people reading this ordinance know that the owners of the residential facility can only rent to particular people for up to 30 consecutive days.
We could certainly tweak this definition to better emphasize that. From my reading of it, I think the second part of the sentence emphasizes that it's owned and it's the principal place of residence for the owners of the property. But it has a rental period for outsiders for that. less than 30 consecutive days. Is there anything you would specifically recommend, or would you like staff to fine tune that a bit and bring you a new one?
I would ask staff to fine tune that, please. If I might add, DPZ, the short-term rental definition makes it crystal clear about the rental period.
Mr. Chair.
Commissioner,
A couple of questions that will also tie into our later discussion about the schedule of uses, but in the case of short-term rental, what is the township's involvement? What's the township's role if everything else fits this definition, but the residence is rented for, what are we calling this, less than 30 days? For 30 days or more? What's the township's role if somebody rents their residence on a longer term basis, 30 days or more?
The township allows residents to rent out their homes for longer than 30 days.
By what? I'm sorry.
We don't have a rental inspection program currently. We allow residents to do that.
By what mechanism do we allow that?
We don't review rentals in that capacity, the long-term rentals.
I'll get back into this in the discussion with the schedule of uses, because that's maybe where it now resides based on that answer. But the kind of part B to this question is, so in the case of a bed and breakfast, same question. If somebody had someone living in their residence outside the period that would be defined if we recommend this to the township board, what's the township's involvement in that?
Well, if that were the case, this commission would have the ability to revoke a special land use permit given to user or the owner of that bed and breakfast.
What if it's not a bed and breakfast? Because it seems that if you go beyond the 30 days, that's no longer within the definition of bed and breakfast. So how about house sharing, something like that? Somebody takes on a boarder, they rent them a room, they may or may not feed them, but they're renting them part of their house, not the entire house. That was the case in my first question. What's the township's role in that?
The township wouldn't have a role in that type of situation.
Yet, aside from the time limit, it would seem to fit the definition that we're looking at tonight for bed and breakfast.
Right.
So I guess same deal. I will bring that up more when we get into the schedule of uses, because I don't think it's the township's intent to disallow either of those two cases. We just want to make sure that we have defined properly, and if the township board so approves, what limits on those particular uses. So I think that takes care of my questions underneath this part. Thank you.
thank you. Commissioner Stroop? Any other?
Chair.
Commissioner Berry?
Regarding Brady's comment earlier on item 12, all bed and breakfasts are required to have an inspection from Chelsea Area Construction Agency and the Dexter Area Fire Department, and shall comply with current applicable health codes. DPZ Ryer, have you had any conversations with either enforcement organization regarding that, whether there should be one inspection and done, or whether it should be an annual inspection.
I've spoken to both agencies and they think an inspection's a great idea. We didn't get into whether they think annual is better than once. I do think that's an excellent question that we could pose to both organizations. One thing I will say is that an annual inspection could be considered burdensome for a BAB operator, especially if they don't have complaints or issues during the time that they're operating that facility.
Mr. Chair,
Commissioner Mark?
what if we made it every 2 years?
Sure.
Because I mean, that every year does seem a bit of a burden, just in terms of maybe nothing would change that much, but I think like every other year would might do it.
Mr.
Commissioner
Chair,
Berry.
on that point, do you know what sort of inspection regime is typical in hotels, for example? And could we use that as a model?
I can't comment on that. We could request that Matt Forrester with CACA draft a letter on how this type of inspection would occur, so you are all aware of everything that they look at when going out to the property.
Commissioner Strub?
I'm sorry.
Either one.
I didn't want to speak twice before you spoke once. I was just,
Well, I was just gonna say in terms of the inspections, I manage a rental community in Dexter. They obviously are not subject to any type of rental inspection similar to the city of Ann Arbor would be, because city of Dexter doesn't have any rental inspection standards ordinance. However, we do have a handful of low-income housing units subject to MISTA inspections. And those physical inspections are once every 5 years. So if something like a bed and breakfast is going to continue long-term, I was thinking if it can pass its initial first inspection, annually seem burdensome. And even 2 years might see it be excessive, but either 3 years or 5 years seem like it was falling within a normal inspection range from a outside agency. And although the city of Ann Arbor does do them annually or every 2 years, do we know?
I'm
For their rentals, because they do have inspections. I don't know if it's annually or every 2 years. It's not every 3 years or 5 years, so.
Thank you, Commissioner Berry. Mr. Strub?
thank you. So in that same section, we say and shall comply with current and applicable township, county, state, blah, blah, blah. Is current to be construed as current at the time they received township approval initially, or current because in some other areas of the zoning ordinance, we have tied requirements to state or I don't know, other regulatory bodies that as those change, it is already incorporated. We don't have to go back and change. What was our intent with current? Is it a one and done, or is it as state law changes, for example? Would there be the necessity to comply with that, and therefore it seems like a more frequent inspection may be necessary?
Brady, correct me if I'm wrong, but the intent is for the operator to comply with their special land use approval. So 10 years from now, we could have different ordinances, an entirely new ordinance. They wouldn't be subject to anything outside of their original approval. However, general ordinances like noise, anti-blight, etc., those would all still be applicable. But they would be tied to their initial approval at the planning commission level.
So then Does current and add anything useful to this section, or should it just say all bed and breakfasts are required to have inspection from the Chelsea Area Construction Agency, the exterior fire department, and shall comply with applicable township, county, and state construction and health codes? This current just confuse things, because what applies.
I do think current makes sense for new applicants coming in. They need to comply with all current standards. I guess
They need to comply with applicable standards, which is already in there.
we could strike that out and it would still get the message across.
I don't want to talk you into anything. It seems like it might remove a little ambiguity that,
Sure.
hey, at this point in time, whatever applies, applies. I
Yeah,
think that would be consistent with, for example, when we referenced whichever state code for fencing around residential swimming pools, things like that. But
Mhm.
we don't have to go back and update. It's just whatever is current, you have to comply with. And I just use the word current, but it goes with the territory, I guess. Whatever it is, you have to comply with it.
I understand. Yeah, that makes sense to me. What is applicable is current.
Yeah. Yeah, if it's, yes.
DPZ rare, if I could jump in here. In my opinion, the inspection prior to granting the license is imperative. After that, I would leave it to the discretion of the planning commission on what the periodicity would be. 3, 5 years, whatever. And while I have your attention, I'd like to change the subject for just a bit, please. On item 13, documentation that sanitary sewer or septic system can handle the increased flow shall be submitted with the application special land use permit. I respectfully suggest the word flow be changed to demand, because flow is a function of pipe size. It is not a function of how many people are using the facility.
That makes sense to me.
Thank you.
Absolutely.
Further comments by planning commissioners, especially on the periodicity of the license inspections?
I thought Chandra made a good point, 3 to 5, somewhere between 3 and 5.
In the process of helping our staff prepare this document, would you, Commissioner Meyer, would you make that into a motion which we can approve or disapprove as advice to staff?
Mr. Chair, can I ask, are we doing one motion for the period and then a different motion for the timing of the inspection? Because I guess one thing that just occurred to me, because you look at section 13, where they have to have documentation of the sewer capacity demand submitted with the application. Why wouldn't we ask that the fire and the construction agency look at that and have documentation with the application? Was that premature?
You can do it 2 different ways. You could require that they have that inspection before they come before you in the public hearing, or you could have it be administratively handled during the permitting process after you have a chance to review everything.
I think the second one sounds good.
Yeah, it seems to me that it should be part of the application process, because there's no point bringing it to the commission if it can't pass those inspections.
I think that's very logical appraisal. So,
So just to reiterate some of the things that were said already, right now, there isn't an answer whether you want the inspection to be annually or between 3 and 5 years. I think we need to hone in on that. Sounds like this group would like to see an inspection and documentation of said inspection occur before they come before you. Chair Birch also requested that we change the word flow to demand, speaking about sanitary sewer and septic, as well as fine tuning that B and B definition.
Sure, just one point to the B and B definition and the less than 30 consecutive days, blah, blah, blah. 9, occupancy, the guest shall not stay at a bed and breakfast for more than 30 consecutive days. Clarifies that. We could somehow kind of tie those together, because I think that's a good point that I think it was the chair brought up earlier. It is a bit ambiguous whether it's rental of the place or the stay of the occupant. But if we can somehow integrate the wording in 9 where it removes that ambiguity, I think we'd be on the right track.
Okay.
I think we're getting close to completing this topic with, in the chair's mind, the only area that we have not specifically decided would be how frequently after the initial inspection will a bed and breakfast be inspected by the relevant authorities. I like Commissioner Hurd's explanation and recommendation. I'd ask Commissioner Hurd to make that into a formal motion, please.
We also have public hearing portion of all of this. Just to keep you on track.
Well, in terms of the frequency of inspections, I'm by no means an expert, so I don't want anyone just to go with my word and without further discussion, but it just seems like 3 years is reasonable. 5 years gets kind of excessive, only because they can make a lot of changes inside the home within 5 years and try to maybe increase occupancy and not get the proper permits. And there could be issues with the sewer system, that things could just be going on there, and 3 years seems reasonable, 5 years seems too long, and 1 year seems too short.
The only thing I'll say about that is if we do go that route, this group would need to make it clear in any approval that that is a condition of their approval, the 3-year inspection. And staff would also need to keep track of these approvals to ensure timely inspections once it gets to that point. And we do have mechanisms to do that in our BSNA software to flag properties for inspections on certain dates. So I'm sure we can figure out a method of doing that.
Thank you. Anything further you desire in this area?
No, I think you gave staff some good direction to make some minor changes to what's before you this evening.
Okay, thank you. And moving on to the amendments for section 1704 K1, etc.
So, is it do you want staff to come back to the planning commission with these revisions next month, or do you want to make a recommendation tonight to the township board?
In the opinion of the chair, I think I would like the staff to come back with a clean document that we can submit to the township board. However, if anyone on the planning commission feels otherwise, please speak now. Hearing none, I believe that we will be looking for a clean document next meeting.
Mr. Chair, just a procedural question, I guess. So tonight is our advertised public hearing on this.
Mhm.
Would there be another public hearing at the next meeting with the exact document that would be before us that we would presumably not further amend? We would pass it on as it is, or we recommend it to the township board for approval or not? What do you think the flow would be for that?
We would not need to renotice this topic, but would open up the floor to the members of the public in the crowd today to give any comments or concerns they have, and to consider those before staff makes these changes, represents it.
And I'm behind a little bit in the newspapers, I guess. This public hearing did in fact get noticed in all the editions of the Sun-Times News that reach, I don't remember how it was broken up, the 3 zip codes, the 3 school districts, 3 whatevers that make up Dexter Township.
Yes, there's a copy of those newspapers in our office, but I did not attach a clip of that notice in the packet.
All right, thank you. Yeah, it is noteworthy perhaps that for the advertised public hearing on this issue that has been going on at least a year and a half now, that we haven't had much feedback, including packed house tonight.
Thank you, Commissioner Strub, so noted. Are we ready to proceed to the amendments to section 17?
Mr. Chair, before we move on to that, I would open the floor up to the public for any comments or concerns about that ordinance.
Thank you for that prompt.
You're welcome.
Anyone from the public care to address our bed and breakfast ordinance proposal?
Must be on because I can hear myself. Linda Selbert. I live at 9586 Winston. So I have, is this a question and answer kind of thing? I have some things for clarification. Okay, so maybe I just ask a question and they can consider.
Right, and we can always talk to you after the meeting.
Yeah, you're
about it.
great at that, by the way. He's amazing. So I looked at this and there's really nothing that talks about occupancy, numbers of people that can stay at bed and breakfast that I could find in the ordinance or in what you're considering tonight. I've looked kind of around. I live on the lakes. You probably know that. And we're heavily impacted by the behaviors of people in short-term rentals. We don't have bed and breakfast, but there are some short-term rentals operating around the lakes. Some are advertising 20 people can stay, 12 people in a house that is 1,000 square feet. So occupancy concerns me a little, and I just don't see it addressed. If CACA inspects, I had called CACA when the short-term rental committee was working on this, and they talked to me about if this ordinance followed building code. There are some regulations, building code wise, for how many people can occupy a bedroom, how large a bedroom needs to be, things like that. They also told me that you get to a certain occupancy number and you are then subject to commercial building code standards. So I do think occupancy plays into this, and how will CACA inspect and make that determination. I also noticed that the sewer people had sent a letter to the board talking about they consider short-term rental a commercial activity and would require a meter be placed on the homes that are going to be used for short-term rentals. I don't remember if it was also B&Bs. So we're talking about it being a residential property. We don't address in here that it's being used commercially and tie in that sewer thing. I don't know whether we should. The other thing I noticed is when you talk about ownership, under the bed and breakfast, you talk about it being a primary residence. Short-term rental is defined as a residential facility with a rental period of less than 30 consecutive days. The lawful rental, whatever. But in bed and breakfast, it says single-family residential facility with a rental period of less than 30 consecutive days, which is the owner's principal place of residence and occupied by said owner during the rental period. Do we want to define that for short-term rentals? Since they kind of fall under the same requirements. And I think that was pretty much what I had. I'm assuming when you get a conditional permit to operate one of these, if your neighbors notify the township and complain, the township will investigate and enforce your conditional use permit. Because I can just see these turning into events, even though you say, I think it talks about determining the number of events may be limited based on the size of the lot and potential impact on the adjacent properties. So my question was just, does that come with the conditional use that this body says, we're looking at the size of your lot, so we don't allow you to have events, and each one would be handled separately? It wasn't clear to me. So I think that's all I had. Thank you very much.
Thank you, Ms. Seward. Mr. Spiegel?
Very quickly, I thought we had, I don't expect an answer. I thought we had defined owner someplace, but I can't find it. I don't know how you can not have a definition of owner. Didn't we work on this before? I thought. Is an owner an individual? Is it a corporation? Is it a partnership? Who is an owner? So you may want to consider defining owner.
Thank you, Mr. Spiegel.
There was a owner definition in the definition section, Article 2. I don't know if that would apply or not. It's in Article 2 definitions under the O.
So I was just searching the PDF and binders.
Owner is defined on page 44 of the ordinance. And one thing I will say about the definitions presented today is that it ties owner to your principal residence. So in that case, I wouldn't suspect a large business or corporation to stay on site. So in my opinion, that concern is covered.
Where are you finding that? We don't have page numbers. We have, or, you know, we don't have like page 44. We've got,
It's 2-22.
yeah, 2-22. And it says the owner definition is the owner of the premises or lesser estate in the premises, a mortgagee or vendor in possession, an assignee of rents, receiver, executor, trustee, lessee, or any other person, sole proprietorship, partnership, association, or corporation directly or indirectly in control of a structure or real property, or his or her duly authorized agent. And perhaps for the purposes of what's before us, we don't need anything else because we're not getting into the details of, I don't think it applies to bed and breakfast, but short-term rental, we're not getting into the details of under what conditions is a short-term rental permitted. If we were, then I think we would want to get into what the definition of an owner is in that case. At least personally, I've stated before, I think there's a big difference between somebody renting out their house for, you know, some brief period, but it's still their main residence versus another business entity owning multiple properties, and it's kind of absentee ownership just for commercial purposes. Anyhow, that's my 2 cents worth. Yeah, I see where it's in there. I'm not sure that it has a lot to do with what's before us tonight, though.
Traub, I recall those discussions that we had about an individual owner versus a corporate entity. And I didn't think that was going to be part of our discussion this evening.
Yeah, I don't think it applies to, I mean, somebody else chime in, please, but I don't see as that applies to bed and breakfast. I think that situation is made clear that the owner of the place has to be on site for a certain number of hours per day. And we're not dealing with that kind of detail for short-term rentals. So I think definition of ownership or how it applies to short-term rentals is not topic of discussion for now.
Chair,
And
I guess based on how broad this definition of owner is, and I'm looking at a version where the definition's on 2-24, not 2-22, so it might be a more updated version. But if it includes lessee, then theoretically, I could be renting a property long-term. And I could then run a bed and breakfast, even though I don't have title to the property under this definition. It would still be owner occupied because as a lessee, I'm an owner.
yes, and that fits our definition on 222 also, which is the current version.
May I ask a question to Fletcher? Since to be a bed and breakfast, you have to apply. Can a lessee apply? They meet the definition of owner, so that all of a sudden just raised just a much bigger issue in my head of everything in here. Can a lessee apply on anything that submit? I didn't think so, but that's why I think we've all gone down the path of that we've understood that the owner principal residents are the two terms that are really making a bed and breakfast different than a short-term rental. And so I think we're okay there as far as those topics go. But again, it just raised that question of if this defines owner as lessee, who can be applying for the special permits then?
Mr. Chair, it seems like maybe we ought to take that whole issue up in a future discussion, because as Commissioner Smith is pointing out, it's also making me think of, well, there's all kinds of situations because zoning goes with the land, that somebody who is just temporarily occupying that land, even if it's under contract, should not at least have the ability to apply for any sort of zoning changes.
True, and in that vein, can a leaseholder apply for a zoning change?
Yeah, it would seem to me that they should not, because the zoning change goes with the land, not with the ownership.
Exactly.
But it seems also that we have such a broad definition of owner that I can see where it could create some confusion. What I thought was pretty clear cut, bed and breakfast, a single family residential facility, blah, 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 in which the owner's principal place of residence and occupied by said owners during the rental period. But yeah, then to go to the definition of owner, well, owner could also be a lessee. Owner could be something other than the person whose name is on the deed of the property as registered with the township.
And at this point, I'm going to make a formal request to staff that, with consultation of legal advice, to give us a definition of owner that resolves this conundrum. Thank you. ABC Rare.
Apologies. I don't think it says lessee. It says the premise or lesser estate. So that's just a property definition. Then further on, it says the person, an assignee who receives, the organization that receives rent, lease.
Yeah, the
Or
lesser
any other
estate
person.
should not be confused with lessee listed on the next line.
Well, anyway, yes, let's just see what staff has to say.
Thank you. All right. Further questions regarding our bed and breakfast versus short-term rental discussion? Mr. State.
Joseph Spiegel, I don't want to give anybody indigestion. Corporations are people.
Yes,
We have to remember corporations are people.
this is,
I remember Mitt Romney saying that.
and this is another reason, Mr. Spiegel, that I'm asking our staff to come up with a definition that will state what we actually think we want to say.
Here. Thank you.
DPZ Rare, do you have enough on your plate on this subject and we move on, or do you have any further questions here?
Yep, I think we had some good direction tonight, so we'll come back with a amended draft ordinance for you to consider in June.
Thank you. Okay, back planning commissioners, anyone have any further comment or concerns regarding the definitions, bed and breakfast, short-term rentals? And may we move to the amendments of 17.04K1 through whatever.
Think, Mr. Chair, I think we would be moving on to the draft Article 4 in section 16.36 ordinance language.
Which the draft Article 4 schedule of uses. Guess I'm going to exercise my position of chair and ask the first question. Uses not listed in the schedule of uses are not permitted. And then we have, and subject to the requirements of section 16.36. What do you mean by this? And before I ask your answer, I've been doing some fairly extensive research, trying to prepare us in general, but me in particular, for our discussions on data centers. And it seems to be a fairly current thought in zoning that if your zoning ordinance does not address an anything, then that anything is not permitted.
Yes and no.
So having said that, the schedule of uses, if something is not in Dexter Township's zoning ordinance in a schedule of use or a permitted use, is it permitted? Is the activity even quote unquote legal?
Well, the schedule of uses is now tied to section 16.36 and the draft ordinance that we have presented to you tonight. The ordinance allows some flexibility with interpretation of land uses. So somebody could come to the planning department and request a use that isn't listed in the schedule of uses. However, it might be extremely similar to a permitted use. And if that is the case, the DPZ has the ability to interpret said use being similar to an allowable use and making sure that parking, traffic impact, water and utility impact, stormwater, noise, odor, etc., are all consistent with something that's already permitted and regulated.
I appreciate your comment there, and I suspected that was be pretty much what you had to say. And I have no suggestion as to what scales you use to balance these permitted uses versus what someone might request as being acceptable. Short of going to the zoning board of appeals for an appeal of your decision.
Right. The ZBA would weigh in if there's a disagreement between staff and an applicant on a certain land use we find not similar to an allowable land use. So there is a mechanism in place in the event that somebody does come in with that argument. However, they would need to prove to the ZBA that their use is similar to an allowable land use and also consistent with the parking, traffic impact, noise, odor, etc.
So, and in other words, if I may summarize my question and the answer here, the phrase "and subject to the requirements of 16.36 is really the key that unlocks the door for you to make a decision on similarity.
Correct.
Thank you.
Mr. Chair,
Mr. Straw.
I'm not sure that the statutory, whatever, 7 elements or so that the ZBA has to find in the affirmative before the appeal can be approved really is in harmony with this section. maybe nothing we have to deal with tonight, but yeah, I get it that ZBA would be the appeals process, but those are very specific questions, including things, like, is this the result of something that the owner did? And I think this is a fuzzier question than that. Yeah, the owner decided that they were going to do this. And that's exactly why they're trying to get the appeal, because this is similar. And yet, when you go down the required decision matrix at ZBA, that might have to be a question that gets answered in such a way that, well, the rest of them don't even matter now because you got the one negative response. So if that could kind of be looked at and see how those mesh together in whatever a typical, ZBA is going to deal with something like, I want to put an extension onto my deck and it's going to encroach upon the water, or I want to add a cover over my porch, but that further encroaches on the side lot line that I already have as non-conforming. These seem less specific than that. And I'm not sure that ZBA, the way all of this is written, would be the place that could grant that kind of relief.
So another way to look at this is, let's say, for example, one of the similar land uses requires a site plan to be submitted. Well, I would tell the applicant, no, it's not similar. They could appeal my decision to the ZBA. ZBA would say, yeah, it is. But then they need to come back in front of you guys for site plan approval or special land use approval. It does leave some gray area there, but I would say the safeguards to all of this is those two approving boards in this process, both ZBA and Planning Commission. For an administrative approval, something that could be handled administratively, I guess that's the only path not getting multiple sets of eyes on it.
What's the process if you, as DPZ, decide that, yeah, this is similar, I think that's okay, and a neighbor or local resident wants to appeal that decision? Kind of the reverse of what we just described.
Let me look at something before I answer that. I'll see if there is even a mechanism for that. So applicants can appeal my decisions, my interpretations, etc. A resident couldn't appeal a decision for a use that's permitted.
So would their remedy be
or
district court? Right.
Yep. They would need to go to court in that situation, but that's an excellent question.
Mr. Chair. Just to comment on this section. You brought up, Mr. Chair, the proposed language in red under Article 4. And I might suggest just modifying that sentence and have it state uses not listed in the schedule of uses are subject to the requirements of 16.36. Because then you're not saying whether they're permitted or not permitted. It has to go through a process, you first, to determine it, instead of saying flat out it's not permitted. I was just proposing to scratch the not permitted comma and just say are subject. And I was trying to think of a similar use that isn't listed in the schedule of uses. Like I have a son who's kind of an entrepreneurial guy who is his father owns a 70-acre farm in Lima Township, and he's asked me, well, could I do a car detailing business here if it's all completely in this little shop? And I mean, car detailing isn't on here. If someone wants to just drop off their car and he vacuums it and cleans it. And then what if I just want to work on small engines? Is that related enough to agriculture to be an accessory permitted use, or is that more related to, automotive repair? But he just like lawnmowers, little small engines repairing. And so those uses really aren't listed, but he would have to come to you and you would have to decide if they were similar enough to a certain category, whether they'd fall into commercial or an accessory permitted. So I feel like those kind of vague uses, they're going to have to come to you to figure out if they're permitted or not permitted, and just, they shouldn't be flat out not permitted according to that sentence. Just my opinion.
Mr. Chair. I guess one reason I would like to leave it as it is, I feel like the whole genesis of this was the discussion of short-term rentals, which are not permitted. Under the current structure we have, they're not permitted. And I think people are confused because I think it behooves us to say it's flat out not permitted. Because otherwise people are not sure.
So that's what I attempted to do with my
Exactly.
original definition of just, if we're gonna not permit it, just flat out say we're not gonna permit it. But then it opened the can of worms with the exclusionary zoning. So we got away with saying it was not permitted. And yes, this is absolutely right. This is the alternative to address the short-term rental. That if it's not listed here, we're not gonna permit it. But we also can't be exclusionary. So if someone wanted to do it, they'd come to our director of planning and zoning, and he would say they're absolutely not similar to anything on this list, and we're not going to permit it.
Sure.
And whether they can go to the ZBA from there, I guess that's their choice as anyone else.
Yep, and reiterating what I said a meeting or two ago, that if somebody wanted to come in, do a short-term rental, I would say that's not related to any listed land use here in the schedule of uses. It's not similar to a motel or a hotel. It's not similar to a bed and breakfast. It's vastly different. And then there's the appeal process potentially after that. But ultimately, it protects the township, not blatantly excluding illegal land use, but to use other mechanisms to manage and enforce the board's decision to not allow that.
Thank you, Commissioner Strauss.
Sure, I agree with what both Commissioner Mayer and Commissioner Hurd just said, even though they seem to kind of, conflict. But I think what DPC Breyer is saying is, yeah, kind of how we got here in the first place. That the township never explicitly allowed, permitted short-term rentals. Therefore, only when somebody called and said, hey, my neighbor has a lot of whatever going on over there, did the township take enforcement. And yet, to be fair to people who don't deal with this kind of stuff all the time, they could go through here and look it up. And yeah, sure enough, short-term rental isn't listed in here at all, so I guess I'm okay. And we kind of spun ourselves into this whole situation. Well, okay, so now what are we going to do about it? And I kind of understand the legal opinion about exclusionary zoning and whatever, but it was kind of our mission from the get-go. I thought that we just need to say what it is. And if something like short-term rentals are not permitted in Dexter Township, yeah, we need to come out and say it. Because we probably need a better legal opinion on that, and better, I mean, like more definition, because otherwise we need to turn this thing into an encyclopedia, the schedule of uses. And it gets back to my earlier issue. Hey, nobody ever claimed that somebody can't buy a house and rent it out a year or more at a time. And nobody ever claimed that you couldn't take on a person whether it's elderly assist, somebody is just helping pay the property taxes or whatever, rent a room in the house. Yet it's not listed as a permitted schedule of use. So how far do the tentacles of township planning and zoning reach? Or ordinance enforcement reach on something that isn't explicitly stated? And we're kind of going all around, oh, we don't want to come out and say that short-term rentals aren't permitted in Dexter Township, but we're going to say if they're not on this list, then nothing is permitted. And I think that's going to create even more problems.
But Commissioner Straub, I appreciate your comments. I think they're very appropriate. However, looking at definitions from earlier, I'm sorry, it's going to take me a couple of minutes to find the exact quote.
While you're doing that, I might just add that maybe we need to define short-term rental as a commercial use, and maybe that takes care of that, because now you can't have a commercial use in a non-commercial zone district. So we haven't been exclusionary about anything. You can turn, I don't want to state specific commercial zone properties, but you could turn a commercially zoned property into a short-term rental, but you could not turn a residentially zoned property in any of the various residential districts into a short-term rental. So maybe that's the better way to do this. But going back to, I think, Commissioner Hurd's original point, yeah, there are uses that the township has no business getting into, yet I guess it is a land use. And there are other things that, well, this is kind of like that, and the township doesn't need an explicit rule for it because it's enough like that that DPZ can make that decision administratively. I'm still hung up over what's our objective with short-term rentals. And I think our objective is we do not allow them in any zoning district that is not commercially zoned.
But, excuse me, Commissioner Straub, in our packet of information this evening presenting these topics to us, the definition of short-term rental that is in here, if I may for a moment read this to you to refresh your memory. A residential facility with a rental period of less than 30 consecutive days. The lawful rental of the following shall not be considered short-term rentals: bed and breakfast establishments, motels, campgrounds, group homes such as nursing homes and adult foster care homes, substance abuse rehabilitation clinics, and other similar healthcare related facilities. So I think that makes it rather clear what is or is not a short-term rental. And we're not permitting the short-term rentals, but all these other things we are.
But we're not saying we're not permitting a short-term rental. We're saying that a short-term rental doesn't appear on here, therefore it's not permitted. We defined what it is and we left it off of here and said anything that's not on here you can't do.
Which is not a use.
Yeah, so why don't we include it on here? And a short-term rental is allowed in a commercial zone district. Because I think that's what state law has already determined, the courts have already determined. And I think that is harmonious with what this body has been discussing.
Mr. Chair, the township board said this, I mean, we'd have to, they said no, so.
They didn't say no to that. They said no to what we gave them, which was, well, I guess we can do it in farms and commercial zones,
Right.
but the commercial zones, there's nobody clamoring to do that. There's no commercial zone maybe that lets that happen. I'm just trying to work around the exclusionary zoning part of it.
At this point, if no one's applying, then I don't think the issue is ripe anymore.
We have any number of properties that are being used as short-term rentals, whether they applied or not. So we're back to the don't ask, don't tell.
Exactly, but if someone complains, then Fletcher would have to address it.
And why is it not permitted? Because it doesn't show up on this big, long schedule of Nor does, the detailed shop inside somebody's barn or garage, or
Why is that not a home occupation?
I think it could be.
I mean, I think we had people here when we talked about home occupations that had stuff going on in their garage.
Yeah, I think it could be, and I,
Which Fletcher would have to decide. Can I just ask one question?
Of course.
On 16.36, where it talks about parking and traffic and all that, why would we also want to consider whether or not it fits in with our master plan?
Well, I believe the reason we could include that, and that's always looked at for special land uses in particular. For a permitted land use, typically it falls in line with the established master plan. If that's something you think we should emphasize, we can certainly look into it. Circling back on this short-term rental conversation, I hear you, Commissioner Straub. However, I will mention that staff did do an analysis on where the existing short-term rentals were located. None of them were located in the commercial zone district. So if we were to go through this practice again and give the township board another ordinance just for short-term rentals in the commercial district, they would probably have the same objections to the last time around. And that was presenting an ordinance that only allowed short-term rentals in the ag district, the rural residential district. Well, none of them existed in those districts, only around the lakes. And essentially we're saying yes and no at the same time. And that's the reason why that ordinance wasn't adopted. I do think the mechanism in front of us today does a good enough job to allow staff the language necessary to enforce that prohibition, with notice of violations that have been sent out to some properties with short-term rentals. This section has also been listed, and its relationship to similar land uses and how they're not similar. I can share that template with you if you're curious what it looks like. Our legal counsel helped me draft a template to send to short-term rentals operating and the complaints we receive on those.
Thank you. And DPZR and supporting what Commissioner Meyer suggested here, I would like to see conformance with the master plan explicitly stated as one of the uses not specifically listed in the requirements.
Mr. Chair,
Mr. Straub.
question for staff. Where does a kid's lemonade stand fall under the schedule of uses?
It does not, and
I'm not trying to just,
We would
gotcha.
be-
It's where
we would be
does that
pulling-
fall?
We would be pulling our hair out if we wanted to regulate every possible land use in the world. No ordinance has enough nuance to contemplate all of these day-to-day.
Why would that not fall under food cart?
Well, roadside stands are an accessory use. I could see it falling under that, probably under the cart as well, if a child wanted to apply.
And I want to get to food cart later. That's my concerns for the future, because I think we've got an issue with that, but it seemed like, okay, somebody wants us to attack this in a particular way, so the township can never be accused of exclusionary zoning. Yet it seems like our schedule of uses needs to expand hugely to have everything accounted for. And I get it that you'll have some leeway as to this is kind of like that, therefore we're going to treat it we're going to treat it the same, but I think these are kind of incompatible that we know what we want to accomplish, yet somebody is telling us we can't just up and say it. I don't know, maybe I'm overthinking it, maybe I'm the only one frustrated by it. But we're going a roundabout way that I think puts a lot of other things in play, because this list has never been all encompassing.
Mr. Chair,
Commissioner Mayor?
if it's never been all encompassing, and I mean, I've been here on 6 years, you've been on a lot longer.
A little longer.
And I just kind of feel like it doesn't actually seem broken to me though. So I feel like it doesn't need a major fix because it's not particularly.
I agree with that until we're about to break it. I think we're about to break it because we are explicitly stating that if it's not on there, it's not legal.
But you
And
have.
we've never done that before.
Thing is, then but it's also subject to section 16.36 where Fletcher could say, oh, that is, you need to go ahead and do that. So.
The way the ordinance is written currently, I would interpret everything through section 16.36. We just wanted to emphasize what it's talking about exactly. So mention the schedule of uses because currently it only talks about uses not listed. Well, what uses? So uses in Article 4, and then tying that section directly into Article 4. So when somebody's looking at that, they can go directly to that section. But this is how we're operating currently. If somebody came to me with a similar land use, I'd go through this process exactly how we've talked about it this evening.
But this would imply that the township has a role in anything that's not listed here, including my examples earlier of somebody wants to rent a room in their house for 60 days, 5 years. That, depending on where it is on that kind of continuum, well, that's kind of close to bed and breakfast. So for 60 days, you better get inspections and go through the special use permit, blah, blah, blah. Or you certainly can own and lease to somebody else your property for 30 plus days. And that doesn't make it a short-term rental, but because there's no such thing as long-term rental in here, the township would somewhat arbitrarily have a say in it. And I'm not concerned about Fletcher's going to do that, but just like the land use goes or the zoning goes with the land, this goes beyond current staff, current planning commission. It sets up a precedent and I think potentially opens a can of worms in the future. It goes back to what Commissioner Hurd suggested earlier. Well, let's just take those words out. Uses not listed in the schedule of uses are subject to the requirements in section 16.36, which is it goes to DPZ for their wisdom and judgment. But then we kind of come back to, well, we're still in the don't ask, don't tell. We have not told somebody that, hey, it really isn't legal to have short-term rental in Dexter Township. We danced all around it.
Can I just note that I think at least has been publicized in various news outlets that short-term rentals are not permitted in Dexter Township. I mean, I saw an article this week about it, and it was from Fridge, Michigan. We covered a ton of different locations in Michigan, Dexter Township being one of them that is not allowing short-term rentals. So I'm just saying, I think the word is out on that one, hopefully.
That's not how you create laws and rules and regulations. Yeah, the word might be out, but if somebody wants to know, hey, what's Dexter Township allow? Here's the document. And what is the impression they get from that? Now, it'd be great if they just called Township Hall and said, hey, I'm thinking about doing this, but people don't typically do that. They end up, hey, my neighbor is complaining about this. I didn't know I couldn't do it. We should lay this out for anybody to see. We should be explicit, we should be intentional, and I don't think we're going down that path.
But wouldn't that just be incredibly burdensome for us to like say, okay, you can't have a slaughterhouse. You can't have, you know, a massage parlor. You can't have whatever. I mean, you'd have to list every conceivable operation in the schedule of not permitted uses.
That's kind of my problem. Once we say only the things on this schedule are permitted, now we gotta count for everything.
But it's always been like that. It's always been that if it's not on the schedule, it's not permitted. It's just that people don't know that because we never stated it.
That's right.
But there are these other things that apparently are land uses, like somebody buys a house and they want to lease it out for a year at a time. According to this, that would not be allowed. And I don't think that's anybody's intention. I don't think that's the township's business. But somewhere between that and somebody wants to rent their place on the lake to strangers for a week, that's not okay.
But Ms. Hurd said what to start, there's like no inspection of rentals in Dexter City, which I. think
Yeah,
is
so,
shocking.
I mean, I would ask staff to look into the long-term over 30-day rental, because I think there's more of a precedence out there than just a township ordinance ever setting standards for long-term rental. Something over 30 days, it's more of a permanent residency. You change your driver's license, you change your address. It's no longer, I mean, it's your home at that point, you're just renting it. But even in rentals in Dexter, we call that person, they changed their address. They
Right.
make all those changes, make it their permanent residence, even though they don't own it.
A long-term rental in Dexter Township is just considered a single-family dwelling. Somebody lives there. We define it as a detached building designed and used exclusively as a home, residence, or sleeping place of one family. And that's a long-term rental. We just don't have a rental inspection program here and never have. Some communities do, but typically they have a larger enforcement department and larger inspection staff to complete those inspections.
What you just described is a single family house. The use of it is not covered anyplace. Long-term rental, we all kind of understand, and yeah, that's permitted because it's not permitted. But if we keep this worded the way it is, we're gonna have to account for that. And we just described the residence, and we described the usage. Under 30 days, can't do it. 30 days or more, we don't care. But it doesn't say that in here.
Mr. Chair,
Ms. Mayor?
would you be okay, Marty, if we did what Chandra suggested and take out the words are not permitted?
Yes, I thought that made a lot of sense when she brought it up, except kind of reflecting back on it. It's that ambiguity. Now, I think we've helped it out a bit because now we have defined short-term rental. That was never defined before. So now we've defined short-term rental. And if you go through here, what do you know? Short-term rental's not on the list. So somebody who was trying to figure this out, at least at that point, she go, not sure what all that means. I'm gonna call the township and then they'll get their answer. But I think that does eliminate, and I know it sounds crazy, but just going by what we're saying, we would either have to list everything that's permitted, or I think take up Commissioner Hurd's suggestion that we just get rid of that. And everybody kind of knows what it means. We've given everybody enough information that, this is a little bit fuzzy to me. I better call the township and check it out. The main thing that we will have accomplished is that we will have defined short-term rental, which had never been done before. And making that a class on its own. And then people reading through the rest of the ordinance and the schedule of uses, I think gets them to the conclusion that they need to get to. It's still kind of don't ask, don't tell, We haven't, beaten somebody over the head with, hey, look at this. But there's enough information there to where they ought to understand that that's not a provision that's been made.
So we can move on. Would that satisfy your requirements for this evening if we followed Commissioner Hurd's suggestion and struck the words not permitted and from the statement, the preamble of Article 4?
Yes, it resolves all of my concerns about we have to have an all-encompassing schedule of uses.
Thank you. DPZ Rare? Are you comfortable removing those words?
I believe so. Yep, I think removing those words still falls within the intent that staff had and what I believe you all had during this conversation.
No. Thank you.
Mr. Chair, if I may,
Mr. Smith?
there was, when thinking back, I thought the whole purpose of adding the not allowed just had to do with making it clear, regardless of the double negative structure of the whole thing. We do have also another section in 106, types of uses, which I'm not going to read the whole thing, but in putting together, there's the opening states that only the types of uses listed below are recognized. And it specifically says permitted uses. Permitted uses are listed for each district. So we're telling them right there that you can only do what is listed.
Yeah.
So we're telling them the positive. So even though the table works in the negative, you can't do it unless it's not listed. But right here, we've told them that. So I think that whether we have the language or not doesn't actually affect the implementation. It's just how we feel it communicates best to the people that live here or would be applying.
Thank you.
Sure, I don't want to beat this thing to death, but that gets us into well, what happens in either of these cases, 30 days or more? We're still right back to that. There are, and there will be other uses. I'm done. If we take those words out, I think it serves its purpose and we get closer to what we were trying to accomplish.
Thank you.
Mr. Chair,
Commissioner?
this will be short. This will be short. Just one last question for staff, if I may. The specific use standards that for bed and breakfast, what we've been talking about, are under the commercial use standards. I'm just wondering why under the schedule of uses, bed and breakfast isn't a special land use in the commercial district. 'Cause don't we have some single family homes or some residences in the commercial district? Like, it's not permitted or special land use or anything. I mean, I would want it to be a special land use, but is there a reason why it's not listed under commercial district?
I believe it's because B&Bs are typically in a residential neighborhood. They're not typically found in a commercial zone district, but you're right. I think there's one or two homes in a commercially zoned property. One off the top of my head is the Esch property. Right down the street, there's a single family home there. Near the marina on Dexter Pinckney Road.
That's actually not zone commercial, the marina.
There's
I think that's residential.
commercially zoned property that used to have a house on it that has since been demolished. I actually had somebody contact me about that today.
I just think
It
it's
does happen.
interesting that it's listed as a commercial, under commercial use standards, but it's not permitted as a special land use in commercial at all. I don't know how anyone else feels about that or if they care, but
Anything further on this topic before we move on? Hearing none, DPZ Ryan, would you like to start with our amendments to section 17.04?
So we already went through that, Mr. Chair. Staff is gonna bring back some changes to those sections in June. We're also gonna bring back some changes to the Article 4 and section 16.36. I believe now we're on to discussion and direction regarding meeting minute preparation and the approval of the March 24th, April 28th, and May 12, 2026 meeting minutes.
Okay, thank you. March 24th, 2026.
At your places tonight, you found, processes and discussion on how minutes are created. The packet that has the large paperclip is for the December 24th. Or the March 24th, I'm sorry. The first document, and I've labeled it in red, this is the clerk's minutes. This is what actually the AI is doing. And then the second document under the little paper clip is what I get from the administrative assistant after she formulates and edits it.
Mr. Chair, may I ask the recording secretary a question?
Of course.
Question for you. Did the clerk's minutes using the new process actually save time and money? And second question is, what is your preference?
In my opinion, right now, it is not saving time. The admin, this normally takes her several hours to do the video and make all the edits. Or she sends it over to me. And then to make sure everything is accurate, I do the same thing. Before I send it off to the planning commission secretary. I can't right now state my preference, that's your decision. After you review all the documents.
Well, let me rephrase the question then. Which process has been more helpful for you to complete the minutes?
My original doing the plan for minutes from scratch, not having AI.
Mr. Chair.
DPZ Ryan.
Would like to mention that Supervisor Scott is in the audience and he can speak on behalf of how the clerk minutes are being used and why they were implemented in the first place.
Thank you, DPZ Ryan. Commissioner Scott? Would you care to address the planning commission, sir?
Sure, thank you. Just wanted to be here also to answer questions. I know I sent an email with the process and thought it might be helpful. I saw that it was on the agenda. So a couple of things of note. One is the AI continuously learns. So the more that we are putting things in, it will be learning voices, all of those types of things as to how it's spitting out sort of the outputs from the meeting. It's not perfect, and that's why we have left the opening for human review in all of our meetings. The township board is using clerk's minutes as well, and then the clerk is reviewing those for our draft minutes. And the only thing that I wanted to say, and I said this in the email, it is perfectly fine. It's up to all of the committees. It's a tool that we purchased for folks to use or not use. That is a decision that each of the commissions can make. But we did so because we were drastically over budget last year. And this year alone, we are headed the same direction. So for the previous month, we were at a little over $1,200 in recording secretary cost. If you translate that out to a year-long cost, we're talking a little over $12,000. And what we have budgeted for this year is closer to $7,500. So one of the reasons that we implemented the tool was to try to speed the process up. The other thing I mentioned in the email is recently, and we are outside of state statute, and that is not a choice that I get to make or that the board gets to make. Draft minutes have to be ready for public inspection within 8 days of the meeting. That is not taking place. And so either way, regardless of what system we use, that has to be corrected. We can't continue to operate outside of state statute. And so those are the things that I wanted to bring. Again, completely your choice. And we were really trying to just help. If it's not working and it's not a process that is helpful, then that's, we tried it and maybe it didn't work. But wanted to be here tonight because I knew you were discussing it in case there were additional questions.
Supervisor Scott, when I laud the township for trying to A, conform with state statute, B, save my tax money in the process. But the way we have described the system, it sounds to me like there's a significant duplication of effort here. If the township clerk has to go through and review what clerk minutes presents before it can then be presented to Ms. Miller for her review and amendments, what are we gaining?
It's a great question. And I don't believe that to be the system that we've set up. And can certainly address that with what Beth, the office assistant, is doing is loading the meetings, and then that raw information should be presented to Janice to review. The human review should be taking place by the recording secretary. And she has the ability to make any of those changes and formatting and those things. Right now, the only thing that the system that we had discussed setting up was for the office assistants to take the actual recordings and upload those into clerk minutes. I can't speak to whether or not for sure that's happening or not, but can definitely have a conversation with the office staff to make sure that they know that that's the expectation.
Thank you, Commissioner Scott. Planning commissioners, open floor.
Quick question for Commissioner. We had a little discussion amongst ourselves about whether the purpose of our minutes is to record the discussions, the elements of the discussions, or just the decisions of the Planning Commission. And I believe we came to the conclusion that it was recording the decisions. Am I first off correct there?
That is correct.
So the purpose for us was to record decisions, which it seems to me would be a much slimmer process, or should be a much slimmer process. And then the second element is that true of others? Are we the only one that tries to only record decisions, or are there other groups that are actually recording the elements of debate and discussion.
I would say that that's still, especially with this software, I think everyone's still figuring it out. The ZBA is going to have a similar discussion, is my understanding, on their next agenda. The FOSPA board has just started using it as well. They didn't used to video or audio record their meetings, so that was a decision they made recently. The township board has actually gone slightly the other direction, where originally they wanted to basically just record decisions, and that's how many of our minutes were. With the AI software, we are including a little bit of discussion. But there are options within the AI software where you can do a short form, medium form, or long form versions that you choose what that output is. And again, that's something that, you know, we can set templates and it starts to learn what things you want included is the idea. Again, whether that comes to fruition in 4 months and it's really learned all your voices and is not still making mistakes is yet to be seen. We're all sort of trying this together.
Okay, because to me, I mean, implementing anything new always takes more time than it saves. You know, that's the conundrum. You spend more to save later. And so I understand that there's an inevitable factor to this. So I think this is an opportunity for the township as a whole to really revisit how are we taking our minutes and what do they contain? And that even though we are different groups and we have our preferences, I think the township as a whole needs to understand how it can make those possible so that we don't throw the baby out with the bathwater. Yeah, one of them may not work for one group, but that doesn't mean it doesn't completely work for the other, or that we don't take the time to learn and figure out how to really leverage that technology the best for us, which in the end, I presume means the budgets, but at the same time, making sure that it is defensible, it's recording and capturing, at least for us, the decisions, which we've had to refer back to, and make sure that we're moving in a, well, it can be contentious. So just make sure that everybody as a whole is trying to see how we can do this most effectively. Because I don't think we can avoid it. It's going to happen in the long term, but let's do it in a smart way.
Agreed.
Mr. Strong.
Mr. Chair, not sure the supervisor, recording secretary can probably fill in the gaps to this, but way back, you know, in the early 80s, I'm pretty sure that Bill Eisenbeiser, who was the township clerk, would just contemporaneously, you know, write down his notes, and at the next meeting, he'd have minutes out of it. And when I kind of returned to the township decades later, it's a much different process. A meeting like this, I don't know, we're probably going to have a dozen motions, fewer than a dozen motions that have to be recorded. Is that done contemporaneously? And then, I guess to you, Janice, do you go back and try to get clarification by listening to the recording and see that, oh yeah, this thing that I wrote down, that is how it was? Or do you construct that? Do you have to listen to the entire meeting to construct the minutes the first time through, up until, you know, the AI thing? So up until recently, because I'm understanding that this process takes a long time and therefore exceeds the budget that had been established, but I'm missing the part, I guess, about why it takes so long.
Speaking back of my doing the minutes without the AI and admin, or do you?
Yes. So your process up until then, I think you're taking notes during the meeting, and then I know you go back and review the recording. Is that to fill in the gaps or just verify that what you wrote down was correct? Do you have to go through, so you obviously you sit through the meeting real time. Do you have to go and review the recording real time for its duration, or you just bits and pieces?
I take good scribbled notes. So my first draft for myself is from my notes. And then I go in piecemeal. If there's a question in my mind, did I remember that right, or did I write it down correctly? I will go in and find that conversation. And I go back in to the actual recording and do the motions word for word. I don't edit motions. Those are your words and those need to be accurate.
So does it end up that to prepare the minutes takes less time than to sit through the meeting or not? Because we've got like 1x sitting through the meeting. What's the multiplier to actually produce minutes that are submitted to whichever body?
It depends on the content of the meeting and the length of the meeting. Sometimes it's, if you have a 2-hour meeting, sometimes it's 2 hours to get minutes. If it's a longer meeting, it takes longer. And if there's more detail that needs to be verified accurately in the minutes, which I don't need to remind you is a legal document that can go to court, I make sure that it is accurate. So sometimes it takes longer for that accuracy so that we're not on the hook for something that won't pass muster.
All right, thank you.
Commissioner Mayor?
This, for the most recent minutes, which not the working session, Janice had sent me 2 versions of the minutes, and one I'll just call the traditional minutes, like I'm used to seeing.
You should have those in your packet. The next group paperclip items are the April 28th minutes. And I'm giving you, what I did was I sat down and did the minutes as I normally do. And then after Chairman Birch said that we should be just doing just motions, I went in and stripped everything out. And I sent both versions to Secretary Mayor.
And when I saw this really stripped down version, I thought it was so stripped down that it wasn't actually informative as to what happened at the meeting. So I started poking around some using AI as well as just other online resources. I looked at minutes for planning commissions in Bridgewater, Freedom Township, Lima, Sylvan, and Webster, as well as Scioto and Linden. And Scioto's an outlier, like they're so detailed. It was like the War and Peace of minutes. It was incredible. But basically, like Bridgewater, Freedom, Lima, Sylvan, Webster are doing more like what Janice has traditionally been doing, which records decisions, but also has some discussion in it. And this is, I did ask Google, because they've expanded their AI mode, about discussion in meeting minutes, and they said, like the last time, and I misunderstood this when we talked about it, Mr. Chair, I thought we weren't allowed to include discussion, but we are allowed to include some discussion. And like the Michigan Townships Association suggests a functional middle ground between just decisions and discussion, that you have a general description of all matters, cases, and issues discussed, so a reader years down the road can understand the basic context.
Thank you, Commissioner Meyer.
I guess my only other comment is, years ago, minutes were the go-to source of information on a meeting, but there now is an option to review the details of a meeting such as ours through YouTube. And if you find the minutes on the internet, then you have access to YouTube. So I would love to find a happy medium between some discussion included without it being a really long discussion, because these details can be reviewed a different way. It isn't really an answer or anything, but it's.
You look at my minutes. Discussion might be 20 minutes long. I have taken out just the highlights of that discussion for information. I don't include the whole discussion, just the highlights. So if the minutes were to go with discussion, you would find all of your minutes 10 pages or longer.
Because I feel like the AI minutes, these clerk minutes, it's very lengthy and very detailed and almost too much. But I think we do have to rely on the recording secretary, if that person does the minutes, to accurately pull out the highlights and not be subjective on what they want to pull out. It just has to be accurate highlights, which I think you've done a great job doing in the past.
Oh, and to note, clerk's minutes gives you a narrative.
Right? And I do know that technology is advancing. We are definitely moving towards AI, and I feel like we have to embrace change, to a degree. Like if this is the direction we're going, then maybe we haven't given it as much of a chance, and maybe this can be pared down to the shorter detailed, much less detail than what's provided here as we heard can be. So I don't want to discredit the new AI completely, because that is the way we're going, and we have to embrace that at some point and give it a chance.
Guys, I had one other thing.
Go ahead.
When I was doing this research on what needs to be in minutes, I was surprised that there's a Michigan legislature website that says you actually do not need to include public comments in your minutes, which I feel like if people show up and have a comment, it ought to be in your minutes, because I think it's rude not to, if they want to share their views, I think they should be in there.
Thank you, Commissioner Bear. Supervisor Scott. Sir, question for you, and I'm concerned about the legal ramifications of what decisions we make here. Going back to long before I got involved with Dexter Township and all other discussions about minutes, which have gone from basically who showed up, what did they say, and when did they leave, to very succinct minutes. Now that we are doing the electronic recording of our meetings, what or how long are those recordings for?
That's really a decision that each commission can make, because the recordings are actually not what's listed in statute. So the legal requirements are minutes, and those have to be kept for certain periods of time based upon, the different types of minutes or those kinds of things. But audio and video recordings, an audio recording, I believe, is still a year and a day, is the only thing that's listed. And that mostly applies to closed session minutes. But video recordings are not a requirement, and the wheels of government turn slow with those changes. So the statute actually only talks about written minutes as your requirements. So they do. There was a little bit of discussion, especially around COVID, around participation virtually, and they believe that the legal opinions are that the legislature didn't intend that, and so you can view remotely, like the township board. We are updating the technology in here to allow two-way communication. So soon during our board meetings, public comment will be able to be someone on Zoom. They don't have to physically be in the building. But board members would not be able to interact in that way. They wouldn't be able to vote. But that's really the only discussion around virtual meetings in the statute that I know of.
Well, thank you. Now, I know it's a cliche, or think it is a cliche, that once it hits the internet, it's there forever. Do you know of any policy about how long our meetings, our recordings are available on the net?
We have archives for years, since we started YouTube. So right now you could go online and view our YouTube page back to at least 2020 and see any of those meetings. We don't typically delete them after they've been posted for that exact reason. Once they're out there, they're out there. But I think and I'm not an attorney. There are several in the room. I don't believe retired attorneys in the room. Still, the written record is what courts are looking at. for these decisions. It doesn't mean that they couldn't look at the video or the, you know, the intents of the meeting, but my understanding is that the actual official record is the written record.
Well, the reason I was raising these questions was to disabuse myself of the idea of we don't have to concern ourselves so much with the minutes because we can always go to the recording. But the recording has no legal merit. So we're stuck with the minutes and what we choose to have included.
And I did actually ask that question to the township attorney as well. Is the 8-day requirement satisfied because we have recordings? And the answer is no. That the statute governing minutes is very clear that it's a written record. And that's what's required within the 8 days and then posted after 5 days after approval.
Thank you, Supervisor Scott. Other commissioners?
Mr. Chair, just the discussion about how much discussion needs to be included. So someplace between discussion ensued and getting down every syllable that each of us has spoken over the course of a meeting is where we really ought to be. And I think where I kind of went tilt last meeting, or the minutes from the previous meeting, that it's important that Fletcher's comments are attributed to Fletcher because he's, you know, professional staff. The rest of us are just talking about stuff. I don't think every comment needs to be attributed to each one of us individually, as long as what could be important points that we discussed, that we have demonstrated, that we gave consideration to this, and this. It doesn't matter who said it. Just collectively, the board has talked about this, and then as I guess denoted by our motions, that's the official action that we take. And the rest of it's kind of the preamble or the how did we get to that motion? It was all of this stuff. Janice certainly knows the important part of a discussion. I just don't think everything has to be attributed to each one of us individually because we're kind of we're all in it together body, as even evidenced by our bylaws, that once we take action, we leave here, we speak on behalf of the body, not individually, that, yeah, those doofuses did this and I didn't agree with it. So it's just kind of an amorphous blob, I guess, planning commission.
Oh, thank you as the blob chair. Any other commissioners?
To continue the March 24th, because that's where you're aiming to approve tonight. Because you tabled it last month. The next paper clip shows you in color my questions, because this was my first experience with the AI also. The questions and the omissions that ensued. That was my personal document. That was
I think in order.
And then the next document up at the top, it says recording secretary draft to see mayor. I answered all my own questions and created the document like I normally do with the AI and the admin edits. I didn't change that. So that document is what I sent to Christie, and then I included it, he sent back to me as her edits. So that is the complete process of the minutes for the planning commission.
Having said that, and I'm sorry, Secretary Miller, I seem to not have the document that my fellow commissioners have.
What is that?
The covered documents that you.
There's
Thank you.
Mr. Chair, if I may, so this is a big process, but how much of this is just the learning curve? Not the ability of the technology, but I mean just figuring out the settings, getting it so that it's spitting out something you can begin to work with.
That's done prior to my getting the document.
So you get this one that's got all the words in it?
No. That is not, that is when an administrative assistant starts the clerk's minutes, she downloads the agenda. And then she marries that with the Zoom meeting. And clerk's minutes then fills in from the agenda the narrative of what was said in those sections on the agenda. So I don't see that first document. That's what the administrative assistant sees.
So who calls, from something like this, which is paragraphs and paragraphs of text down into, I'm trying to even find what it became the first time around. I mean, it looks like it took it down about half.
The administrative assistant.
So there's someone else making a pass on these before you got it and then made a pass. And then, well, you answered your own questions and then sent it off. So there's four passes here. So it seems to me that somewhere in all of this, that's kind of the learning curve where we need to be able to get it. So it goes from 1 to maybe 2. And, perhaps getting from this big long one, maybe this one was set to long rather than medium format or.
That's the medium.
Okay, well, medium to short, whatever. That hopefully what could happen is with a few more iterations of this, we can get it so that we can go through that much quicker. So that you're getting something to you, so that you're able to check the human side of it, because I believe that's the purpose. And especially one of the strongest values you bring is that human side, but that we can eliminate 2 or 3 of these processes here. So I'm going to just call that the learning curve for now, because I don't know what happens behind those walls. And I guess what I would love to see, I do think that the idea of having minutes that not only record our conversations, but a few of the highlights of the topics, the salient topics would be nice. That's our goal, and that you're able to help train this thing so that we can get to the point where those minutes are what we're after in a timely fashion without 18 or 4 steps in the middle. And granted, knowing that this is the first, we can almost immediately know that it's the roughest of rough drafts on the process, let alone the document itself. So I would hope that there's a way to get there pretty quickly in the next few meetings.
Clerk's minutes will not pull out just the highlights of the discussion. The software is not created to do that.
Well, I would hope that it's between the training process and then if we can get to the point where we know, and I say we, I'm using not just the Blobby Planning Commission, the Blobby Township, that maybe it's not the right product for us. Maybe we just either we didn't know how to set it correctly, or we've been through all the settings and now we know it's just not the right product, but at least we know what we're looking for the right product to be. So I guess with that, now that I've said all that, what I'm wondering is what are we trying to approve here for tonight? How do we move forward?
Yeah.
Do we have to pick?
March minutes. There is the AI component, the administrative component, the recording secretary component, and the edits from the planning commission secretary. That is the draft of before you for approval or whatever it's going to be.
Is the plan, is the one that includes the secretary's comments. So is this what we're trying to approve?
There's one more.
Or is there one more?
There's a reappro- one.
Yes,
Okay.
Oh, these are just the process copies.
this is just my educational information. to the
Gotcha. Okay.
Would you care to share any documents I have?
Well, you have. I mean, I'm guessing the one that we would make a motion on. Based on what I have in front of me, correct me if I'm wrong. Is the version that has a recording secretary draft to. Christine Mayer, Commissioner Mayer, with her edits that were incorporated into it. Now, is there a version that's after this, or is it this draft plus her edits make the final version?
Brad Seemeyer is a is what I have put together. If you're looking to approve one, the planning commission secretary edits is the final version of everything. It says PC secretary editing read on it. I wrote that on it. That's what she sends back to me, and that's what I publish.
Christine, if you have that version, can you hold it up? So we know.
It had.
PC secretary edits, so it's your final edits. Okay, that's what I thought. That's the one I was referring to that was attached to the RC draft.
This is a document that we're going to be. Ladies and gentlemen, moving on next to the first item on the approval of planning commission meeting minutes. Item A, March 24th, 2026. Are there any changes or conflicts to the minutes of March 24th that you would suggest we make?
So, Mr. Chair, we're working on the one that's in our packet.
I assume so. I did not get it, so I assume that's what we're working on.
Okay, I mean, the one that was in the packet that we picked up from, from the tub with the entire planning commission info for tonight.
Yes, because that,
Yeah, okay.
the version of the packet is the same one as the piece, my edited version in Janice's instructional packet, but the edits have been accepted.
All right.
Revisions.
Okay,
So there's no revisions left in the one in our packet.
okay, thank you. That clarifies it.
Okay, so, Mr. Chair, you're looking for a motion for approval of those minutes?
That is correct.
All right, I would move that we approve the planning commission minutes for the March 24, 2026 meeting.
I'll second it.
It has been moved by Commissioner Straub, seconded by Commissioner Meyer, that we approve the minutes of the regular meeting of the Planning Commission Tuesday, March 24th, 2026. All in favor, say aye.
Aye.
Any opposed, say nay. Motion carries. Next item we have is the approval of the April 28th, 2026 meeting minutes.
Mr. Chair, I have a couple of issues on this one. On item 5, We missed an A, just a typo. It should say data center issues. And then at the very end, under adjournment, we had a motion, it was supported. All ayes, motion carried. I just think we should include that the meeting was adjourned.
Mr. Chair. This,
Commissioner Mayor?
I just wanted to point out that the the April 28th minutes in the packet were, Janice had given me those to me, and they were extremely brief, and I did add some information back in there. So,
And that has been incorporated into what I have in your packet.
right,
You have one that says the regular version, which I produced first. And then the lean version, which I stripped everything out. I sent both of these to Secretary Mayor. She chose to edit the lean version based on what was said at the previous meeting. That discussion shouldn't be included, just motions and actions. So what is before you is the lean version, which you look down the aim discussion, there is nothing there in the lean version. So if down the road, somebody wants to come back for information on what was discussed in regards to bed and breakfast, short-term rentals, or data centers, it's not there. But if you go back to my minutes, you'll find that I have just pulled out the highlights again. Not attributed any discussion to anybody. So you've got in your hands what a lean version looks like and what a regular version looks like. But what is before you tonight is the one that Secretary Mayor edited, and that's the lean version.
Chair, I'm a bit confused, I guess. What was the purpose of the lean version? Are you suggesting that the one that was in our packet is maybe not the one that we want to approve, that one of the others that are in tonight's paperclip would be more appropriate?
I mean, at this point, these minutes, the 28th were done based on my understanding that we were not including discussion. So I did add back in like what the public commenter said. But other than that, there's really not a lot there. So, you know, for purposes of just moving forward, we could just go ahead, I think, and approve this lean version. But then for the future, if you don't want something this lean, we should add discussion back in, which would be my preference, is some discussion, because I feel like this is too lean.
Yeah, so in that case, if we're still dealing with the one that's in the packet, then I guess there should be one more edit, number 9, approval of planning commission minutes, moved by Straub, seconded by Hurd, that we do not approve the minutes. That before that it has a strike through, I guess should be omitted. So it says, do not approve the minutes as presented to us tonight because they're inconsistent with the type of information, blah, blah, blah. So that, I guess, was part of the edit and just needs to be removed.
Removing what?
There's a strike through.
The one that's in our packet, yeah, there's a strike through 4 lines from the bottom.
Yes,
The minutes before us,
yes,
or before as.
okay.
Correctly. Through that, does that say before? As, yeah, so that before, that's a strike through should just be removed.
Video. Zoom. Make sure that motions are accurate. Sometimes you guys make a motion and you go back and change a word or two in it. This is the original motion. After the motion was made, somebody said, well, maybe not the word before, but just as presented to us tonight. So that's why I struck that out there.
Yeah, and I'm just saying that we don't want to approve it with the strike through, right? That word just gets tossed.
If you want me to remove it, I can, but that was the original motion.
The original motion had a strike through.
No, the original motion had the word before. That word was in the original motion. After the motion was completed and seconded, somebody said, maybe we don't need that word before in there. So that was like an amendment to the motion, but I just went back and struck through that before. I can remove that out there.
Right, I get it that I may not have been very eloquent, likely was not at all eloquent making the motion, but this doesn't even read right, so I'm not sure what it ought to say. I thought the before was an edit, therefore it ought to be removed.
Is there any further discussion?
I don't want to change history, I'm just not sure that that before belongs there. But if it was said, then I guess that's,
Talk to your secretary. She can tell you what she,
Go ahead, remove before.
I will remove it.
Thank you.
And we will entertain, are there any other changes to the minutes of April 28th?
I will move to approve that minutes of April 28th.
As amended with the striking of the word before.
The other typo.
yeah, the data, and then add that the meeting was in fact adjourned after the motion carried. So that therefore would be the one that was in our packet that we picked up. Yeah, I'll support
Yes.
that. Hmm?
Adjournment says, motion by Mayor supported by Abbott to adjourn the meeting at 8:11. So where do you want adjournment at?
Well, it doesn't say the the meeting actually was adjourned, wasn't it?
At 8:11 p.m.
Yeah, but it doesn't say that it was adjourned in the minutes.
It does.
Where does it say that?
Under 15 adjournment, it says, motion by Mayor, comma, supported by Abbott, comma, to adjourn the meeting at 8:11 p.m.
Yes, and then we voted and the motion carried, but until the chair declares the meeting is adjourned, the meeting is not adjourned. It, just to be consistent, I think in other places, our minutes say the meeting was adjourned. Not that big of a deal maybe, but,
Formatting language, and I can make it.
well, no, but the process is that somebody moved it, somebody supported it, the chair asked for a vote. We voted on it, the vote passed, but then did the chair gavel the meeting adjourned? If so, that should be stated.
Yeah, that's. The chair declared the meeting adjourned.
Give me just a minute here, because I think it was in the minutes we just approved.
Yes.
Minutes we just approved. Motion, Secretary Mayor moved to adjourn, Commissioner Abbott seconded. Meeting adjourned at 7:19 PM, no vote taken. I think the chair did gavel that. Yeah, I think it's accurate that there was not a vote. The chair just gavelled it adjourn. But I thought it was, I thought we typically would say the meeting was adjourned, not just hangs on a vote.
I would just add that the meeting was adjourned.
Okay, got it.
Are there any further amendments or changes to the Tuesday, April 28th, 2026 meeting? It has been moved by Commissioner Meyer that we approve the minutes of April 28th as amended. Do
I
we have
support it.
support?
Yeah.
Supported by Straub to approve the meeting as agenda. All in favor, say aye.
Aye.
Any opposed, nay? Hearing none, the minutes of April 28th are approved.
Just as an addendum, in the April 28th minutes, I included last week's Board of Trustees approved minutes for the previous month to show you how their minutes are constructed and formatted. And it's not the lean version. Up at the top, I said compared to the PC minutes.
Yes.
Just so you have more information. Make your decision.
Okay, I'm lost. Got it. At the, the very back of that packet.
Mr. Chairman, I can add one thing about this.
Supervisor Scott.
As I said earlier, we are all learning this, and Clerk Sambuelis and I have talked about this. Those minutes were the longest we've had in quite a few times as well, and we agreed that she's not going to continue to present the long form. So we're still trying to find our happy medium with the process as well. So those are very long. That is a much longer format of discussion. And I don't think you'll probably see those approved by the board in future versions. Those ones were approved as we continue to learn, but I think we will be working to cut ours back down as well to find the happy medium.
Thank you, Supervisor Scott. Commissioner Meyer, may I put you on the spot for a moment? Since you are the point person in the planning commission for dealing with the minutes after Recording Secretary Miller has submitted them to you, do you have an opinion as to what you think you would like to see in the minutes as we go forward?
I would like to see, basically what we've been doing, but, and if there's any way we could cut that, make any discussion more pithy, that would be good, but basically, I think that they need to have some discussion in there. I did not like the very lean version. I didn't think it was particularly informative.
Thank you. Any other comments by any commissioners? And a question for the recording secretary. Ms. Miller, how do you feel about pithy conversations?
Define pithy.
Short and to the point.
I mean, we can also, Janice and I could also talk about this, you know,
Well-
put our heads together and talk about it, but.
Go back.
And one of our charges this evening is to decide as a planning commission what we want our minutes to look like. I am trying to elicit the opinion of each of you, but especially that of Secretary Meyer, as she deals with them initially for the planning commission. But I would like all of your input on what you want to see in the minutes that is not there, or what you don't want to see that is there. Keeping in mind that it's a township policy that we try to economize on our minutes, but still keep the minutes relevant and legal.
I think one thing that Mr. Stroud brought up was, like, if Fletcher says something, it should be attributed to Fletcher since he's our DPZ. But I don't, like, if it says here, Secretary Mayor identified an inconsistency in voting terminology, I don't need to be called out. It's like, it doesn't need to be attributed to me. You could just say, you know, planning commission, you know, noted inconsistency and made it, you know, work to make it consistent or something. I don't think it needs to be called out when everyone. I mean, it is kind of, it's hard sometimes, Mr. Chair, because I'm looking at the minutes of March 24th. at the time when Vice Chair Hurd proposed adding explicit language, I mean, that was actually, I think, kind of a big deal. That we wanted to, we thought about adding that, then we didn't do it. Then we, we just, I think it needs to be documented that that was brought up, so people knew we considered it. But then eventually, it was just, and I don't think it was discarded then, I think it was discarded the next meeting.
That statement attributed to Vice Chair Hurd was not in the AI document. It was not in the admin document. That is what I put in. If you go back to the one where I got things highlighted in blue and red, you will see my comment, Hurd's actual comments, question mark. So and that document, like I said, is my personal document. That's what I went through and looked at the AI and said, this needs to change, this needs to change, this. And so that I did put that in with it. Because I thought it was important, just like Secretary May thought it was important.
And I understand that we're under budgetary constraints, but, we've had a number of very lengthy meetings in the past year. The short-term rental was 4 hours. And our meetings have been 2 to 3 hours generally. Sometimes they're shorter, but not often.
And it takes time to decipher and put all that into a document that isn't too wordy, and it shows you a synopsis of what happened, not everything. If you want to go back and look at the last ones that you just approved, it says Tuesday, April 28th, regular version.
Okay,
So going through that, if you look at number 8, discussion items. Review and discussion of draft bed and breakfast ordinance language. The discussion items I pulled out were verbiage changes, consecutive days versus continuous days, importance of having popular uses defined, and defined uses not in the schedule of uses. That's just the highlights of that whole discussion, and that discussion was lengthy, if you remember.
yes.
So what would you like me to do to change it? I'm open to anything.
Commissioners, the silence is deafening here.
I'll fill it.
Please do. Smith?
I hope I'm speaking for everyone as a whole, but I would agree that those are the important elements. And that it's worth having in the minutes. What I'm not clear on is the process to get there. And whether it's because we need software and a person reading it afterwards, if we need a person only, or what the pathway is to get there. I don't have that simple answer. I think we can all agree this is where we want to go. And probably what we need to do is put it back to the township staff as a whole to figure out how to get there based on, is it a balance of technology and people? Is it people? Is it technology?
The current technology will not do that.
Well, that's where we need to see it trained. So supposedly it can be trained.
Yes, can we do this? Can we do this? The answer is always no. It's a narrative. Who
Right.
said what? That's what the software is.
So I'm going to guess we're not the only commission that will be asking this exact same thing. I mean, we all seem to be coming to the conclusion that we want a little more than just who voted what, but we don't want the big, long, wordy thing. So that's where I think that there's going to be there's commonality amongst all of us. And that really, I think, just like we put a charge to Fletcher, hey, can you do A, B, and C? Then maybe we can put a charge to the township to how can we do A, B, and C? And it's going to take time. We can't vote on an answer because we don't have an answer. other than to say, we like this, but it's general. And that we just have to see over the next 2 months, 3 months, 6 months, I don't know what this process takes, the evolution of it.
May I answer your question that you said, how the process and how did we get to what was written?
Yes, but I'm going to put a but in front of here. Yes, I want to hear what you have to say. The but that I'm going to put in there is, I think that we're going to have to keep looking regardless of what's right or wrong. So yes,
We have to find the software that does what the bodies want. To answer your question on how we got to the highlights, that comes from my extensive experience with planning commission, CPA, board of trustees, and everything, to know what is important for them.
and that's where I'll be curious, because a lot of AI trains itself based on the existing body of knowledge. And because our entire body of knowledge is based on your notes, that if it truly is training based on our body of knowledge, that maybe it can emulate. I'll stay positive, hope.
I'm just wondering, I mean, I liked the regular version. I mean, I agree that this is condensed to the point that it still gives us information, but you're saying it's not the AI version. But can the AI version still support some of this information? Could you still refer to that overall summary of discussion to support what you're putting in here? Or does it just get in the way? Or is it just something that you wouldn't even refer to?
Since I haven't had much experience with the AI to this point, I don't know how I would go through all of the narrative discussions and delete, just to get the one point that was important for the minutes. It'd be time.
So you're saying it would get it, it's getting in the way of how you want to produce the minutes at this point?
If I may add on to what you're saying there, perhaps where it comes to is it can help you with all the other housekeeping stuff, knowing that discussion items is where you're going to have to focus your time more. But if it can at least help, like with the public comments, picking up names and addresses and whatever else we have later on in here, that really, I think number 8, discussion items, is always going to be the one that you'll have to put the most meat into, but let it help you the other sections.
Other comments, commissioners?
So we have to vote, we have to do, we have to review and approve a May version also, right?
We do have that option. Yes.
Which wasn't in our packet. This was just what was on the tables when we came in. So is it that we need to review tonight, or is it actually still in process and ready for us? Okay, so I think that
Okay.
answers that.
Then
The work session minutes.
So
work session.
John, that is complete. That is complete. I have, AI was not involved in doing anything of this. I put together the minutes.
okay, but at this point, it hasn't been reviewed by our secretary.
May-
so-
If I'm misleading, is the issue.
Yes.
It's this one, not the one that says. Beer eaters.
Yeah.
I was Dan was the one. who-
Oh, yeah, Dan.
Yeah.
Yeah.
I wasn't here, so yeah.
Yeah.
That's why I included it, so that you could see that somebody else other than me had eyes on it and made appropriate edits.
Oh, Commissioner Berry, since you were secretary de jure for that meeting, do you have any comments regarding the minutes as presented?
No, I don't. The meeting minutes were complete as far as I could tell, and I approved of them. The process from my vantage point was quite smooth, but I'm sure that was different than Janice's experience.
Mr. Chair,
Mr. Strong.
a few comments on those minutes on the second page. We recessed, the chair called a recess at 8:01. I think it would be better where it says 8:07 instead of open meeting, reconvene meeting. The open would imply that we may be recessed to a closed session, which was not the case.
Okay.
I wouldn't want anybody to be, confused by that. And then under public comment, second line from the bottom of that section, Mr. Spiegel said that the best defense is a good offense. We could probably spell that offense with an S instead of the English way with the C. And then I don't want to be all picky, and now that I'm fixated on whether or not the minutes say meeting adjourned, this has probably been like this for a long time, and I'm just now, I guess, am fixated on it, but motion by Straub, seconded by Abbott to adjourn the meeting at 8:37 PM. I think it would be better to say motion by Straub, seconded by Abbott to adjourn the meeting. Motion carried, and the meeting was adjourned at 8:37 PM. It sounds kind of picky, but there is actually a mechanism that somebody could move to set a time limit on the meeting, and that's of course not what we were doing. We didn't move to adjourn at 8:37, we did adjourn at 8:37 after the other stuff. So if that isn't too picky, I don't want to incur the ire, especially of the retired school teacher.
I will make that.
Thank you.
Is that all right?
It's okay with.
Oh, that's right.
Thank you, Commissioner Straub, and I move that the 8:01 recess comment be amended to 8:01 recess at discretion of chair. Do we have support?
Support.
Moved by chair, supported by Commissioner Straub to change the wording of the minutes, 8:01 recess to 8:01 recess at discretion of chair. Any further discussion? Hearing none, all in favor, say aye.
Aye.
Any opposed, nay? Hearing none, motion carried. Okay,
You've got your amendments done, you need to approve the minutes.
now we have the amendments done. Now we can approve the minutes. Yes.
I move that we approve the minutes as amended.
Moved by Straub, seconded by Mayor to approve the minutes of the work session of Tuesday, May 12th. Any further discussion?
As amended.
Hearing none. All in favor? Aye.
Aye.
Any opposed? Nay. Motion carried. The minutes are amended and approved. Next item on our agenda this evening is correspondence. DPZ RAR.
Good evening. There is correspondence at the end of the packet from Sean Weber. He requested to include a citizens committee's draft of a data center ordinance for your reading and consideration. We have also received correspondence from Joe Spiegel in the audience tonight. I can share that information with you at the end of the meeting.
Thank you, DPZ RAR. We do not have a representative from the Board of Trustees this evening, and the supervisor has departed. So we will dispense with item 12 and leads to item 13, concerns of planning commission members. Commissioner Smith, what concerns, sir?
None tonight.
Thank you, Commissioner Smith. Commissioner Straub, your concerns, sir.
A couple of things, please. I would request that as a future agenda item, we review in the Article 4 schedule of uses, specifically food cart, which by our definition also includes food truck. I don't know, 2 or 3 years ago, time flies. I don't recall exactly when it was, but Planning Commission discussed whether or not there should be regulation in the zoning ordinance about food trucks. And our conclusion was that they're already regulated by other entities, including Dexter Area Fire Department. Now, whether people bringing a food truck in know that or not is a separate issue, but we had a presentation about, as I recall, about the inspections, make sure that everything was done in a safe manner, including even, parking and, don't block fire lanes and things like that. But because we were going to take a mostly hands-off approach, yet it appears in the schedule of uses, it seems that we should expand the use to ag, RR, LR, maybe some other places. So I just like that dealt with in a future agenda item. And then the last thing I had is, I think for the first time probably since kindergarten, I think I screwed up the Pledge of Allegiance tonight. I think I skipped a whole section. So I will arrange remedial training with retired school teacher Janice Miller and be better next time.
Your concern was noted.
My head was elsewhere. I just got a whole section out of there.
And DPZ RAR, do you acknowledge Commissioner Straub's request for food cart? And our future agenda item?
Yep.
Thank you.
Yep, I'll look into that and hopefully this summer we can dive into it.
Thank you. Commissioner Berry, your concern, sir.
Just one. I am concerned that we don't all have the same version of the zoning ordinance. It appears my page number was different when we were discussing earlier.
And I believe Secretary Meyer also had the same concern. I do know that the staff is very helpful, willing, and agreeable to providing us with the current version of the zoning ordinance. And I know that from personal experience.
How do we know if our ordinance is out of date? That's the question. Is there a number to refer to?
I would compare it to the one on the website. There's
There's an
PDF you can
amendment.
download, but if that could be printed out, that'd be.
There's an amendments table
Like for-
on the very
Okay.
last page,
Thank you.
and the latest amendment was November 18th, 2025. So if yours is different, you have an outdated version and we can update it for you.
That is all.
Thank you, Commissioner Berry. Secretary Meyer. Thank you, Secretary Meyer. Vice Chair Hurd.
No concerns, but I did want to announce that the next Master Plan Review Committee meeting is on June 17th at 6 p.m. here at the Town Hall.
Thank you, Commissioner Hurd. And the chair is not going to take up any more time this evening. So we're going to go to public comment for the second round.
Joseph Spiegel, 7905 Sauer as a citizen. The memo you got, I'd just like you to strike Paul Kissinger's name from the top. But other than that, the memo I sent, I'm going to stand on that for now and not reiterate the points that I've made in that memo. I would just like to emphasize taking a hiatus, 45 to 60 days, in order to have some focus groups, community engagement. And I know that the supervisor is going to be sending out materials, but I think it's very important we don't put the cart before the horse. Few focus groups, whether it be farm subdivision, Dexter Chamber of Commerce, or any, business environment or lake organizations, to get involved with the issue of data centers. I think it's going to prevent a large amount of difficulties. Communication, communication, communication. Because if we don't do that, I think we'll have the same problem that Celine had. Pitchforks and torches. And I don't want to see that happen. And I don't think it's good for anybody. Because with anything, there's always two sides. There's opinions on one side and opinions on the other. In the memo you got, I reference both another view of what data centers can do. So I want to emphasize we need community involvement, and then we can present the community with a version of a data center ordinance that they have some foreknowledge of. So thank you.
Thank you, Mr. Spiegel. Ms. Silver?
Linda Salbert, 9586 Winston. I don't know why I always have to think of that so hard. What is my address? I just want to thank all of you for the amount of time that clearly you put into preparing for these meetings. The thoughtfulness, the way that you listen when people do come before you. I wish more people would. I do think, I think it was you, Marty, that said in one meeting, maybe the public really trusts that what you're doing. I think I did that for a long time. I come in and often I'm ready to speak and I just think, no, I'm going to sit and see what these guys have to say. And you generally cover the concerns that I would have had. You're just so well prepared and you really do a great job for us. So I really want to thank you.
Thank you, Ms. Silver. And now that we have completed public comment, we have DPZ, you're not off the hook yet. Future agenda items.
Sure. At the work session 2 weeks ago, this group had a ton of comments and recommended changes for the data center ordinance that was presented to you. We are working to integrate all of those, but needed some more time. So we will bring that back before you in June. Additionally, we also put out notice of these continued conversations in the loop memo that goes out to the community. We're also exploring other options to get more residents involved. Because I think we can all agree the public input has not been enough, and we'd like to see more faces in this boardroom when we discuss important issues like data centers.
Thank you, DPZ. And with nothing further on the agenda,
Mr. Chair, may I ask?
I'm sorry, recording secretary, I missed your statement when I was doing the rounds. I apologize.
Bated breath. On the agenda tonight, we had approval of 3 minutes, but the D was the discussion and direction regarding meeting minute preparation process. Lots of discussion, but there was no final decision on the meeting minute preparation process. What do you want me to put in the minutes for that?
You got us.
You know.
I will, in my power as chair, I'm going to open the discussion to the planning commission and ask someone to eloquently and succinctly make a motion as to what we want in the planning commission meeting minutes. The floor is open.
I will volunteer that I think they should be pretty much what we've done historically. They should definitely include public comment. They should have definitely reflect the decisions we make, and they should have enough discussion that people can understand, and the reader 2 years from now can understand the major points of what went into our decision. That's what that was good.
Mr. Chair, I just add that
One moment,
Yeah.
Mr. Straub, I can only write so fast here.
you can watch it on the YouTube. The AI will catch it.
Not in repeating the motion. Now you have the floor, Mr. Straub.
Thank you. I was just going to agree with what Commissioner Mayer said. I just don't think it's my business to say how we achieve that. I agree with what she said about, I think the minutes that we have had historically are good. I think they contain, the proper balance of, discussion and high level review of the actual action that we took. But I really don't think it's my business to tell anybody how we get there.
Unfortunately, I mean, those are wonderful comments, but as of right now, we do not have support for Secretary Myers' motion.
Was that a motion? If that was a motion, I'd support it.
Thank you. Any further discussion on Secretary Myers' motion? Hearing none. It has been moved by Secretary Myers, supported by Commissioner Straub, that our minutes conform to what historically they have been. Especially we want to include some public comment and also include a discussion to support the public comment as we continue on in the future. Before I call for a vote, did I cover it, Secretary?
We want discussion that will support the decisions we made.
Thank you. Does anyone want the motion restated? Hearing none. For the recommendation for the Planning Commission meeting minutes as moved by Secretary Meyer, supported by Commissioner Straub. All in favor, say aye.
Aye.
Any opposed, no. Motion carries.
I do want to state that this is not set in stone. This motion is just for until something else comes along that you need to consider.
Thank you, Recorded Secretary. Is there any further business we wish to discuss this evening? Hearing none, the floor will entertain a motion to adjourn.
So
We adjourn.
Moved by Commissioner Straub to adjourn. Is there support? Support by Commissioner Meyer. All in favor, say aye.
Aye.
Any opposed, nay? There are none. At 2100 or 9 PM, the Planning Commission meeting is adjourned.
Thank you.